Gamer. I'm chairman of the TIP Standing Committee. Wonderful to have you here. We have a room full of mentors, a great panel of mentors. The mentees are going to come and welcome to the bar. We'll have drinks and cocktails at 5 o'clock, and we will be done by 5, I assure you. This is a great opportunity to ask people who have been there, done it, encountered all sorts of issues, how they responded to it, how to make the most of the program. At this point, I'm going to be quiet and turn the program over to Justice Saeda, who really spearheaded and got this thing off the ground. And it's an interesting history as to how we got here. Justice?
Good afternoon, everyone, and thank you all for being here. And thank you for being a part of our TIP program, Transitioning into Practice. What is important about this program, and I think that, for better, it has been lost over the last couple of years. TIP was the outgrowth of the former Bridge the Gap. Everybody in here who experienced Bridge the Gap? Everybody remember exactly what you learned in Bridge the Gap? Well, that's really the point. We started very small as a group of Clark County bar folks initially, and we said, Bridge the Gap just really isn't taking us home, and professionalism is an issue. This is something that we not only want to practice good law, but we want to practice being good lawyers. And so the State Bar took this up. And although Greg gives me credit, I was there and along for the ride, most assuredly, because I think this is a great program. But Connie Ackridge is truly the one who brought this program home from Utah. There are mentor-mentee programs, professionalism programs throughout the country. And various state bars have tried, and some have been successful, and some have not. But the fact of the matter is that bringing a young lawyer, and I don't use that term necessarily related to law, because one of my first employers is actually here. And although I may have, at the time that they hired me, I may have been a new lawyer to Nevada, but I wasn't that young. So technically, I still would have been considered a young lawyer for purposes of this type of professionalism or new lawyer training. Bridge the Gap wasn't taking us where it needed to take us, and it really the model for teaching professionalism and maintaining a string of professionalism comes from a relationship, and that relationship is what you all will be creating with your mentees. How many of you have been mentors before? So I'm preaching to the choir. The fact of the matter is that we took, at Connie's urging, we took a program that is modeled after the Utah program. We tweaked it a little bit. We created it to make it Nevada specific. And once again, although Connie and I would very much like to take credit for the program, we brought it home. It was your state bar staff that developed the program, that developed the curriculum with the help of certainly experts in the field. But they are the ones that made it, by the way, the award-winning program that it is. We were recently honored a year ago by the National...
It was the ABA.
The ABA.
And we're the small bar section of programs.
Bar section, yeah. Honored us with the success of this program. And I will also tell you, when I brought this program to my colleagues, because it had to be approved by the Supreme Court, as you may know, Bridge the Gap was a mandatory program. TIP, I'm proud to say, is now a mandatory program. They were not convinced. My colleagues were not 100% behind this concept of mentor-mentee. It wasn't something that Nevada had ever been comfortable with in the past. I described it as an intern program or a residency program, and that even drew more furrowed brows and confusion about whether or not it would work. The next obstacle became whether or not we would have enough qualified, solid mentors to take care of the incoming number of new admittees that we would have. And again, thanks to your state bar staff, that was never a problem. We continue to match, I believe, the new lawyers with great mentors, and the program speaks for itself. We at the court have had the experience of law clerks coming back after they've gone out into private practice and said they thought they were ready to be out in the big world, and they found very quickly that they were not, and that the mentor program was something that not only helped them for that 6 months, but certainly has sustained them as they continue in their career path. So that's pretty much the history. The rest of the program is, the time should be spent with these experts who have all been mentors and know some of the pitfalls, if you will, or can answer some questions about concerns that you might have. You do have a full packet in front of you, but since you are mostly all experienced mentors, and you understand the contract that you sign, and you understand the curriculum that you have to get through. But we'll spend a little bit of time going over that with you, just to be sure that it's that you're comfortable with the process, and that we are maintaining the high level of excellence that this program demands.
Before we jump into the nitty-gritty with our experts, I want to give you a little bit more of the history, and because it lets you understand where we came from when we started the program. Justice Ada was committed to professionalism. The people that showed up at her professionalism seminars were all the people who were the professionals. And they were the people that were doing it right. And how do you get people to do it right? We started the program in the middle of the meltdown. Half of those people that were graduating didn't have jobs. They were opening up and putting out shingles. And you know how scary it is for someone that just graduated law school who thinks they know everything and knows how to practice law and to keep a trust account and how to interview a client and to keep your bank records together to practice law. And we were scared as to what is this bar going to look like with these kids, and kids being newbies, not necessarily age-wise, coming out of school, not having the experience to do this right. We already had our hands full with all sorts of issues that were created by the meltdown in terms of inability to pay bills, inability to even pay bar dues, all sorts of economic horrors. And now we add these lawyers that are going to be out there on their own. And so it was a perfect opportunity to change a program that really wasn't working that well. You go to 3 years of law school, you don't need to sit down and have another 8 hours that are just going to teach you more law. You want to know how to be a lawyer. And then there was another part. And this is the hard part to translate. How do we keep our culture of a small bar? When I came to my bar number is 270. When I came to this town, you picked up a phone, you called up any lawyer, you had a question, just about they would answer the question. They would refer you to the right way to do it. It was a smaller bar. And we were getting bigger and bigger. We had national firms coming in that were flybys. And yet, this was a great place to practice law and a great place to be a lawyer. And Bill knows it. Bill was there even before I was there. And how do we keep that? Older than dirt. And how do we keep that? And that's part of what we're trying to do here, because we felt, as the justice said, it's all about relationships. And this is building that first relationship. This is that person that's graduating law school who may not know anybody in Nevada, may be a long-term Nevada, and you don't know, this may be a second career. What do you do when you get in trouble? How do you get yourself out of trouble? How do you avoid it? Have a lifeline. You're all lifelines. So that's the history.
One of the things, I guess two things that I'd like to add. The mentor-mentee relationship developed out of a desire to heighten the professionalism of our new lawyers. But I think a byproduct of this program has been the engagement of all of you and you-type lawyers. Bringing the experienced, the professional, the solid lawyers in our practice into a group where we can talk to you like this and spend time caring about our profession. That was a byproduct that we didn't expect. And because unless you work in a big firm, you don't usually have the older attorney, new attorney relationship that you can count on. And sadly, and I think this sets the stage for what we're all going to talk about and what Greg touched upon, the court that I get to work for is the final arbiter of discipline matters. And unfortunately, I can tell you that in the last 3 years, we have seen a significant uptick in bar discipline matters. And while a number of them are, one end of the spectrum lawyers, new lawyers, sadly, the other end of the spectrum are seasoned attorneys who have found themselves in trouble. And when we gave this presentation in Reno last week, I had just come from a draft conference where we did, and I stand corrected, Greg, I think I said that we did 18 cases. We did 20-plus discipline cases in a one-month conference. And that's very sad. And they were all, these weren't just the temporary suspensions. This was a very depressing conference. Of course, we did the draft work, the opinions that you've read, I hope, in the last couple of days that came out. But the fact of the matter is these were very, very serious discipline matters where a number of attorneys were actually suspended. And that's sad. We don't like to see that. So we hope to keep the new lawyers out of that or off that track. And I think in this program with these type of solid, with all of you as solid mentors, we can do that.
So having already said that Bill was older than dirt, now I'm going to back that up. 43 years a member of the bar. 43, right?
That's pretty close to dirt.
And so, Bill,
Mud at least, Your Honor.
when you started, did you have a Bridge the Gap program?
No, absolutely not.
So this is pre-Bridge
We had a, how do I do a prelim?
So have you been a mentor before?
Definitely, since the beginning.
So I'm going to let you talk about whether you obviously like the program, what you think is most effective about the program, what you think a mentor has to do to make it effective. How does that? And I'm going to start with that at first meeting, setting up the plan.
You're letting me go first.
Absolutely. Age before,
All
whatever.
right. Because I do nothing but criminal work, the way that I approach the mentor program may be somewhat different. Because I do nothing but criminal work, I am in court every day. And as I look out there, I'm thinking to myself, why am I lecturing these people when we have very renowned people that I know have been mentors before? But luckily, I also look out and I see deputy district attorneys, I see public defenders. Particularly in the criminal field, it's one thing to go to law school and learn what the crime is and learn what the criminal procedure is. It's another whole thing to understand the practice when we get down into the trenches. So because of my criminal practice, the way that I do it is I leave for court every morning at 20 minutes after 7. And I have been involved in the program since its beginning because I'm a big believer in it. I was involved in the Bridge the Gap program, and quite frankly, I wasn't a big believer in it because we sat through the 8 hours, and in certain situations I even helped teach it. But the reality of life is we weren't teaching them how to practice law in the state of Nevada in the courts that we have. And that's really what I think that I'm there to help do. So when I take an individual over to court that early in the morning, and it's when you mention the first meeting, we will get a call from the individual that wants to participate in the program. And luckily, the staff of the members of the bar, since they know that I only do criminal work, will normally assign me somebody that wants to do strictly the criminal work. So if they're not with the district attorney's office, which has their own internal program, or they're not with the public defender's office, which has their own internal program, they're usually working for or want to work for one of those entities, and certainly are with perhaps a civil firm that doesn't do a lot of criminal work. So what I want to do is to take them over there and make them aware of who is on the other side. So I will introduce them to the deputy district attorneys, the clerks, the court reporter. You develop a rapport with all these people. That's what I try to teach them. And obviously you be prepared. Now along the way we end up in the district court level. And we talk about things like a petition for writ of habeas corpus or a mandamus, or we're here for a probation revocation procedure. So what I try to do is make them aware of all the different types of procedures that they're going to be dealing with if they're going to deal in the area of criminal law. All these things that I've mentioned are not unique to the practice, but they're unique to the state of Nevada. You know, you have to file a petition for writ of habeas corpus within 21 days. If you don't, it's jurisdictional. You're out of court. It's that simple. These are things that we take for granted, but the new practitioner, unless he's read the specific rule, doesn't understand that. So God forbid he ends up with a criminal case, wants to file this thing called a writ of habeas corpus, and does it on the 30th day. He's going to be in real trouble. I think it's important that you learn the idiosyncrasies of every judge, the idiosyncrasies of every deputy district attorney or other public defenders that we work with. When Her Honor was on the bench here, we knew she was going to hit the bench at 9 o'clock. You weren't late for her court. I cannot say that for every district court judge. So you make the deputy or the individual aware of the fact that, look, if you've got multiple appearances, understand which judge hits the bench timely and which one is consistently late, so that they're not missing court appearances if you're going to, or being late for court appearances. Apologize to the court if you are late. I'm sorry, Your Honor, I was in another department. But what we also try to do is make them feel a little bit more comfortable in the courtroom environment, because even though they've gone through law school and predominantly they've had their moot court competition, etc., like that, they are not that comfortable in the courtroom. So you try to make them feel at ease a little bit. Now, is there room for improvement? Absolutely. What I have seen is that, and certainly it's maybe unique unto the civil practice, a lot of the civil practitioners and a lot of the mentees never get into a courtroom. So they never get a chance to see the different district court judges. Send those people to me. If they want to go to court on some morning, I will be happy to tell them and happy to show them around, because most days I'm in both the justice court level and the district court level, and quite frankly even in the municipal court level. It's just the way the practice is. I might say to somebody like Jeff, who's sitting here, Jeff, I've got a mentee. Can they sit here and watch and see what goes on in the courtroom? Because we work with the district attorney's office and because they're part of this program and they have their own internal program, they're going to say absolutely. I might say to the judge, Judge, this young lady is with me. She just graduated from Boyd and she's learning the procedures. And what we stress to them is never walk into a courtroom unprepared. Never walk into a courtroom thinking you're just going to wing it. I see too many practitioners now, even now, that are not criminal practitioners that don't understand what a DUI admonishment is or a domestic violence admonishment is. And, I don't want to pull them aside and say, this is a form that you have to review with your client before you enter any type of a negotiated settlement, but perhaps we have an obligation to do that. But there is always room for improvement in the program. But as far as the bridging the gap versus the TIP program, immense change. And I think that it shows in the type of practitioner that we're producing, whether you're civil or you're criminal. Now, I heard Her Honor say disciplinary matters. And unfortunately, I do a lot of disciplinary matters. And if we're going to make an impression on a practitioner, do it early so that we don't end up in front of the Southern Nevada Disciplinary Committee and ultimately end up in front of the Nevada Supreme Court. Mr. Kamer is right. We deal with terms, but we don't deal with practicalities. We talk about trust accounts in law school, but the reality is that they don't understand what a trust account is and the differentials between, that isn't your money. You can't just, pay the gas bill with it. And that's where new practitioners sometimes get in trouble with that type of differential.
Bill, thank you so much.
Thank you.
We're gonna
Sorry to go on.
No, you're great. Shay, are you doing totally civil these days?
I am. I'm just the opposite.
We're
of
moving
Bill.
over to Shay. And why don't you talk about your opening meeting as a civil practitioner with your mentees?
That's pretty easy. Basically, when I get the letter from the state bar, I kind of challenge myself because these new attorneys seem to be a little overzealous, and they usually email me. So I try to see if I can contact them before they contact me, or we pass emails, and I immediately set up a meeting. Usually, we get our letters about a month or like 3 weeks before the TIP program starts. And so my first meeting, I always try to schedule it. I prefer a Friday, and I let it be. It's always in person, that first meeting, because that's technically where the individuals to sign our mentee contract. And I go ahead and schedule that. This is the first time I've had 8 mentees, and this mentee is my first mentee that I have yet to meet with, and we're starting the program. Usually I meet with my mentee before the program even starts or shortly thereafter. And at that first meeting, it's really interesting what Mr. Terry said, because he's in court a lot. Because I do civil practice, I'm probably in court, if I'm lucky, once every 2 to 3 weeks, depending on what my calendar's like. And so what I usually do at that first meeting is ask the mentee, what are your interests in? Like, I'll have a good idea the firm they're working at. Because myself, I work at a small firm, so more than likely my mentees are from another law firm. And so I'll try to find out what their interests are. And so when I have a hearing or something, I'm mostly in district court, I can email them and say, hey, this is what's going on. Feel free to join me. But that's usually how I set up.
Shay, you and Nancy and myself and several others were actually on the committee that put the TIP program together. And then you went off of that and became a mentor.
Mm-hmm.
You crafted the program, and then you went into the program, something I haven't done.
Right.
What was surprising to you when you went from designing it to practically doing it? Were there anything that you did that we didn't anticipate?
I can tell you one of the most awkward experiences, and I'm going to look around the room to make sure the person's not in the room, but it's worked out. one of my mentees, we had actually interviewed for a job at my law firm. I wasn't expecting that one to get that person as my mentee. And it's going to happen because of the time period they're interviewing. And I kind of was pretty nervous about that is, oh, what's this first meeting going to be like? Out of all of my mentees, her and I are probably the closest. The development of the program, we didn't anticipate that. There's no way that the State Bar, when they're selecting mentees, are like, who all interviewed at your firm in the last month or so. So that was kind of the one thing I wasn't prepared for. I think there's, and this is just me being picky on the program, there's like a lot of overlap. And so there's easy ways to kind of sneak through the program if you want to shortcut it. And then there's, and I try to avoid that, but there are. I mean, it was just, there was a lot of work in developing it, but there's some kind of shortcuts. There's a lot of overlap, so you can kind of take advantage of that to meet your electives and your mandatory requirements.
Thanks, Shay. Now, Ed, you do domestic relations exclusively, right?
That's it.
And so on my list of topics to cover, personality conflicts with mentee. I figure that must be something that in your practice you've dealt with all along.
Just me, maybe. I
But,
don't know.
right. But how many mentees have you done?
I don't know, probably 6 or 8. State Bar knows. I just get a phone call one day that says, we're going to assign 1 or 2 people to you this round or whatever
And
it is.
in the course of the people they assign you, are these folks that are mostly interested in a domestic practice or just anybody?
You know, it's been 50-50. Actually, I'd probably say more people that are outside of family law than are in. I've had a few that are in family law, and there's more of an opportunity for me to be able to enmesh them in what we do in our practice. But my background, I started out as a prosecutor in another jurisdiction. So I have enough that I'm familiar with the criminal practice, and we have a lot of overlap in my practice that overlaps. So I spend time working, you know, if I have a criminal or an employment issue, I'm going to pick up the phone, I'm going to call you. I mean, the most valuable thing I have that I've developed, I think, over the course of the 20-plus years I've been in Nevada is the Rolodex, for lack of a better word. That's the word that you and I would use that not everybody else uses anymore, but it really is. I mean, it's so. In other words, if I have somebody who says they're really interested in doing employment law, part of this process is going to be, you know what, we're going to arrange to go to lunch with Greg, and we're going to have spend some time doing that or something like that. And so you get to know who the people are to talk to, because what makes Nevada unique, and everybody here knows this, is that, and I practiced, I practiced in 2 other states, and there is nothing like the relationships you have in this state between lawyers in the judiciary. I mean, there's nowhere else where I could imagine within a year of being here, I was going to be sitting in Ely, or what was Tonopah then, for the Family Law Conference, having beers with 2/3 or 3/4 or all of the Supreme Court. And you don't have that opportunity in other states, so we all know each other.
It was a classroom.
It was a classroom, I'm sure it was. It was before Justice Aida was on the bench. There's no more drinking since she's been on the bench.
In terms of my topics to cover, one of them is conflicts that arise with the mentees. Have any of you on the panel had any conflicts with the mentees, or the mentees have conflicts with you all?
No, I'm very easy to get along with. Not like Mr. Keenan.
But Ed, have you had any
I'm
conflicts
teasing.
with any of the people?
You know, I've had I think 2 over the course of doing this where I've kind of lost track of them, where they've sort of just faded away or whatever. And usually what happened, I mean, one of them, she ended up losing her job at the firm and was working another job outside of the practice of law, and things had changed. But what I do is I just reach back to the State Bar and say, hey, I've lost touch with this person. Can you guys make an effort? And I think both times they've been able to reestablish it to say, okay, and I'll get a report back. She lost her job with the firm. She's waitressing, and she's ready to get back into it. And so, I mean, that kind of stuff. So they've been a real help in those kinds of things.
So I know I've got a room full of experienced mentees. Have any of you had experience with conflicts? And I'm gonna bring the microphone over to you. Get my exercise for the day. Thank you, Kathleen.
I'm not even going to disclose the gender of the person, but I had a mentee, I don't know how many I've done. I think I started with the program, I'm not sure. This individual was just really not interested in practicing law. I could not understand why this was a requirement, because this individual was only working part-time, was just waiting to stop working, and couldn't care less. And the only way I even got her to meet, the only way I got this person to even meet with me was to offer a lunch several times at a very nice restaurant, which I always had to pay. I mean, this was just not her thing. And in that instance, I just kept working with her and working with her. She didn't want to tour a courthouse. She didn't want to see a courtroom. She was just not interested. So in those instances, I found all you can do is the best you can do.
Did you actually sign the paperwork that released her and,
Well, I
and
made
checked
sure
off
that
the
she did
issues?
do what she needed to do. She was not happy necessarily, but
So you ended up being a taskmaster.
yes, I pretty much had to. Because rather than being one of these, as you were talking about, Shay, or they're so anxious, she was not interested.
Now you're back, so you must have had some good experiences.
Oh,
with
I've
her.
had wonderful experiences, but I'm just saying, if you have an experience like that, I think all you can do is just essentially require them to do it and make it very
And
clear.
of course, bar staff is there. You're not ratting them out. The point is, they're supposed to be doing this, and it's something that we want them to do. And whether they realize they need to do it, it needs to happen. So it's critical that you keep an open dialogue with bar staff when you're having those problems. We get to take the credit. Bar staff does all the work. That's what I say, and it really is in a lot of ways true. They're there. They're a resource, and they're more than happy to jump in and help.
And you also have to remind them of the realities. I was pretty direct with her sometimes. Maybe this great marriage you've got is going to go away someday. And you've got this JD degree, and you don't want to screw it up by not completing.
And this is your ticket, and this is going to help you keep your ticket.
Exactly.
Have any of you, either on the panel or in the audience, had actual legal conflicts of interest that arose because of the mentor-mentee relationship? Shay?
Kind of close, but it didn't really happen. One of my mentees, the first time I met them, was at a special master hearing, and they were on the other side appearing for a party that they represented. And that was the only time that happened. And then we kind of worked it out that she just wouldn't be on that case, and it basically resolved before we really kicked off the mentorship program. But that was an interesting way to meet your mentee when they come up to you at a hearing and they're adverse to you.
Shell,
basically.
I think you were going to jump in on that.
I was pointing out this gentleman.
Carl?
I had one experience. It was kind of interesting because one of my first mentees was someone that worked for Allstate Insurance Company and a staff counsel. I'm also a staff counsel at Travelers Insurance Company. And you got to be careful, kind of, because you can't let the secrets that your game plays versus what their game plays. So we couldn't be real specific about some of the things that we did or some of the things we did. We could do, in general, talk about what was going on relative to defense law. We couldn't be specific as to, well, I have this problem. I can't talk about the problem. No, I can't do it because it creates a conflict of interest.
But you were still able to have a good mentor program.
Yes.
Could you pass the microphone to Jen? Because she's going to hit me. She's my partner. So, Jen, didn't we have a similar situation with one of Scott's mentees?
Well, it was after the TIP program was done, but one of our partners, yes, went up in a case against his former mentee. And that was a little interesting because despite the mentor-mentee relationship, I think some of the conduct during that case surprised my partner, and they kind of had a little private chat. What's going on? Come on, didn't I teach you better? Kind of thing happened. But it was after the
But the beauty of that is that's what this program's all about. It's about having that culture where not everything becomes a nuclear war, and you build the relationships to say, there's a better way to do this. There's a way to resolve this without being at each other's throats, that going to the professionalism of it all. So there's so many pluses to be had. Are there any questions from the audience? Janet's got a question. Could you hand her back the microphone?
My question is, how much effort do you make into tracking them down and whatnot? I mean, I had my first one, maybe I just scared her off, but we met over at cocktails, and then I sort of figured out what we needed to do, and I mean, she was not interested, and she's like, she would only pick the times when I already told her I couldn't meet with her. And I'm like, seriously, yeah, but I talked to the bar staff, and apparently she sort of got it pushed to the next program, so that was resolved. I didn't have to deal with it, but sometimes it's like, I mean, if these people are going to be lawyers, and if they're, how much do you have to be?
Let me answer the question this way, because I don't. Each thing is individual to the mentor and the mentee within the parameters of the term sheet and the checkbox. But as the standing committee, we deal with issues such as, can I get another extension? Can I get another extension? I can't afford the $350. I lost my job. This is what my rent is. I don't have the money. And that's a tough one, because we've all been there. Most of us weren't born with silver spoons in our mouths. Most of us struggle. Some of us still have student loans to pay. And you get somebody that's just out of law school that says you can't do it. This is how the standing committee dealt with the issue of somebody that contended that they were unemployed and destitute and didn't have unemployment. And we said, okay, fine. You're going to have to pay your bar dues, right? This is how important we consider it. This is part of that process. And so with a unanimous decision, we said, you will be able to pay the $350 over time. You will have to pay us $35 a month. If you get a job, we will update those payments. We will require a sworn affidavit as to your financial circumstances. So we take it pretty seriously. Because there's lots of obligations you have as a lawyer. It's showing up in court. It's being prepared. It's maintaining that trust account. It's responding to your clients. It's not letting things go forever and ever. And at the get-go, at the gateway, which is what this program is, we want to establish and impose upon these mentees that obligation. And you don't want to get into an adversarial relationship. By the same token, there's expectations. Justice?
I think one of the answers to your question needs to be that that's what the Standing Commission is here for and that's what staff is here for. If it becomes that your efforts to do what is a mandatory ticket to practice is not on their priority list, you report back, because I know we'll take action. I mean, the fact of the matter is everyone has scheduling conflicts and everybody can miss a meeting a couple of times. It's a 6-month window of time. There's a very defined program that needs to be, checked off as you go through it. If you can't get your mentee to do it, I think you come back to the State Bar and or to the Standing Committee and we'll resolve it for you.
Thank you, Justice. Ed?
Yeah, I was going to say, one of the things that I've tried to do is when I meet with them, I usually try and cover whatever we're going to cover for that meeting. But I try before I lose them to set up the next meeting. And we set that date and we discuss at that meeting what we're going to do at the next meeting, what the homework assignment is, or what they have to read before they come back, or whatever it is we're going to do in anticipation of the next meeting. Now, things happen. Cases come up, schedules change, whatever. If that meeting doesn't happen, my impetus is normally to put that on them. In other words, I'll call, if it's me, I'll make the effort. If I have to cancel something, because a case came up, I have to go to court, I'll make the effort to reschedule. If they've blown off the meeting or couldn't make it, then I put it on them. And sometimes what happens is it rolls around, all of a sudden I'll get an email from the State Bar saying, hey, is coming up on the end of this period, has so-and-so completed? And I'll say, no, I haven't heard from them. Or if it's pretty obvious that someone hasn't, and then they'll get the same message that I get that says, okay, they've got a 30-day extension or a 60-day extension, and they're then coming back to me with the, geez, we got to get this thing going. Can you help me out? And my take on it is this has to be a priority to them. I'm not going to be the one to chase them around. I'm going to make an effort. I'm going to do what I would expect someone to do as a mentor, but I'm not going to be their mother.
Anyone else on the panel want to jump in? Yes, sir.
So what kind of rate is there of people that effortlessly, seamlessly complete the program versus people that are having issues?
Do you know? We've got one bar staff in here. Kim, do you know? We've got the director, the Kim Farmers in the back, our executive director.
It's a pretty high rate of the
Yeah.
who admitting wanting. It's an outlier, someone who doesn't meet with their mentor. Sometimes there will be a personality or a financial issue, but it's very rare where we're chasing down the new attorney. And when we do, it takes a lot of our work. We're usually being passed the next cycle and the next cycle, and they're proud children, but one is Michael, baby, it's not that high.
And I would like to say we have had incredible success with our mentors. It has not been a problem recruiting quality mentors. You were all approved by the Supreme Court to be a Nevada mentor. I think that in your curriculum vitae on your websites, that's certainly something I would be proud of if I was a mentor. It's something I would put on my website because you've been given the imprimatur of the Supreme Court to say these are quality practitioners. And people have seen that as a reason why they would want to be mentors. In addition to the fact, the success of the program is seen in, just to say it as colleagues, embracing it now and not questioning it. It's seen in the CLE board now extending more credits to the mentors for being mentors. And Kim, what is that that the mentors now get for being mentors in terms of CLEs? It's 6.5? When we first started, we were lucky to get 2. 2. So obviously, y'all are doing something meaningful, and it's being reflected by the CLE board. So I love this program. It's been a great success. I think it will continue as long as we continue to maintain the energy and the vibrancy. If we need to change the curriculum, if there's corrections that you think need to be made, don't sit there in silence. This has always been a dynamic program. That was the problem where Bridge the Gap became ossified because it kind of fell into a box. We don't want this to be ossified. We want this to be living and dynamic and responsive to the practice of law as it evolves. And the only way we can do that is by getting your feedback in the exit interviews and by getting the mentees' feedbacks in the exit interviews. So anything else that you all would want to bring up right now about the program or questions? Yes, sir?
I'd like to get some comments or ideas regarding cooperation between mentors and traditional supervising attorneys in firms.
Give me a little more
Make
context.
sense? Okay. When my mentee says, "Oh, I've done that. Oh, I've done that," my supervising attorney can let you know that I've done that. He can send you a letter that I've done that. Do we do it again, or is there any cooperation that takes place with that supervising attorney, or do we take responsibility for this ourselves?
Good question. Who wants to take it, Shay?
I think technically we addressed that issue when we were creating the program, and technically that was not the easy way out to check the box. But I run into that all the time because I'm in a small firm and most of my mentees are either sole practitioners, which still scares me, or they're also in a small firm. And so, or even, actually I think I have my first mentee coming up who's in a large firm, so I anticipate that to be told to me all the time. And at times what I'll do is it usually falls under Section 5, the elective portion, is I make them talk to me about it. We basically have a dialogue about it. I don't just let them go, I've done it, check the box. I kind of make them talk to me about it. But one thing I wanted to I hope hopefully I answered your question, but self-servingly, one thing I think for mentors, if you guys don't know this yet, and I live by this and I should have added it in at my first meeting, is I always go every year to the State Bar website. There's materials on there for us that are under, you go to the Nevada State Bar, you click under Member Services, you go down to Membership Info, and then another box opens up, you go to Tip Mentoring Program, and then you go to Mentor Resources. You have to be quick with your little mouse, because it closes up on you really quickly. And it's broken up, the tip, whoever put this together, I don't know if Stephanie did it or who did it, but did such a great job, is under the Tip Mentoring Plan resources, it's broken up by each section of the program that you're doing. And so, I don't share my fee agreement anymore. I'm like, why do it when the State Bar has a great fee agreement for all different types of fee agreement, for a third-party payee, for flat fee. I just start printing that stuff off. So that was one of my tips I wanted to make sure you all knew about before we left today.
Shell, I saw you taking some notes. Do you want to add anything to that?
Yes, thank you. I did want to bring that up, too, because we were just discussing that before the program began, that in anticipation of speaking about this today, I did click on the link that was at the bottom of the agenda that was sent to me, and I was amazed. I went ahead and printed off. This is, I don't want you to think that I've always had this. I just did this today, in preparation today, but I was amazed at all of the resources and materials that have been provided, and I'm very impressed with that. And there was also an interesting article that was provided about that I just read today that I was unaware about when hiding in plain sight, when lawyers struggle with addiction and with problems that come up, and we may not know or we may not want to report them, turn them in for problems that we might anticipate, But I think that this problem is, and I've always disregarded every time this topic is brought up in different scenarios at different CLEs that I've attended. But this article was, I felt worth reading. It was called, what was it? Hiding in Plain Sight, I believe is what it was called. And I think that most of us have actually struggled with something that we may be even completely unaware of. You know, most of the time we think of drugs, alcohol, or gambling, but there's other problems that start to affect our practice. We may not even be aware of it, and that might be not returning phone calls because maybe we got a bad result in court one day and we don't want to return a phone call from the next client who just happened to have called, and we know that this is a particularly problematic client, and how that can kind of stumble and lead and multiply, and addressing that and facing that. And so I just wanted to bring that up. And the other thing that I wanted to mention was, are there alternative, if anybody has any suggestions for this, alternative plans for non-traditional employments? Because it seemed like I've had several mentees who don't necessarily work for law firms, but they work for the government in some other capacity. And so a lot of the categories that are provided in the plan, the mentoring plan, they don't necessarily fit nicely into those. So
What you have are the mandatory subjects,
yes.
which are going to help you practice if you ever get thrown out into the pond. And then you have the ability to tailor in the electives for that particular mentee. Is that, because Shay, you're more into curriculum design than I was. Don't they have the right to do that in the actual electives, to create an elective that suits the particular type of practice?
I think there is one, or you can, but I think it kind of covers, I think there may be a section in there that does like transactional, and then I think, wasn't there, I thought someone did draft a government section. I thought someone from the AG's office did.
There should be enough
there was.
things
I don't
that
think
alternate practices should be in the elective formats. Now, on another topic, because you were talking about discipline, and we are always so concerned about discipline. What percentage would you say of the discipline you're reviewing, well, let's just go last month because you had a big month with 20, were in some way substance related?
Not as many as I would like to be able to say it could be attributed to. Because, once again, the State Bar program has now several programs that are available to deal with abuses and neglects, whether it be gambling or drugs, alcohol, overeating. There's a number of other, the program, I mean, if you're not familiar with Lawyers Concerned for Lawyers, there's all kinds of other type of programs. And the reason that I said not as many as I would like is not because I want to say that our lawyers are suffering from addictions, but at least my first take on that is that's sort of a reason. It at least explains your downward
But that might be a
spiral.
good thing. You know, if the diversionary programs are actually working, which is what they're supposed to do, it might be a good thing that you're dealing with just incompetence
Yeah,
and moral failure.
Malfeasance and
issues.
Yeah, I mean, I will tell you that, and you know, there's a lot of things that you ultimately see when people respond to the petitions that are filed against them for discipline. That we're all old enough. I'm just going to say it. You know, well, it wasn't really my fault. You know, it was. You know, we see that a lot. I know the State Bar sees that a lot. It was something else that caused my embezzlement of $100,000, or you know, and that's just not a good way to go. Can I just go back to the question about what do you do if you have somebody, I don't remember who asked it, who says they've already done it, been there, done that thing. It's your responsibility as a mentor to be sure that it has been covered. And I know that that's kind of an ambiguous bit of an answer. Don't take their word for it. Somehow require them, whether it's like, as Shay says, to show me how you did it, or show you why you did it, why you think you've done it. Because we did spend time in curriculum development dealing with, for instance, larger firms where they have an in-house training program. And how are we going to require that large, very skilled, very good firm to adjust their intern program or their training program to what the State Bar thinks is appropriate? And we figured we gave enough latitude within the program. But the bottom line is we really do want as much compliance with the program as you can possibly get, or dump it back to the state bar. If it's someone that doesn't fit within your area of specialty government employee, get it. And I'm sorry, I don't mean to be asking for people to send their mentees back. But if it's not a nice fit professionally, we'll find someone to whom
I
you can.
heard a while back that a letter from the supervising attorney was satisfied. Is that not the case?
I honestly don't know the answer
I
to
mean,
that.
I kind of went Shay's route, though, the one time it's come up. In other words, we had a discussion where we might have done more in the way of exercises or things like that, or done an activity. And in this case, we just spent time talking about what came out of that, what did you learn, describe the experience, sort of an in-depth pursuit of the qualitative nature of that experience, whatever it was that was designed to substitute. And I think that, in my mind, that met my obligation to make sure that part of the program was completed, and it had been completed, just really sort of in two parts, kind of the discussion with me and then the actual activity with somebody else.
When you're signing off on the mentor program as the mentor, you then are giving this candidate the opportunity to go out and practice. So my response to you after hearing the collective wisdom is you as the mentor have to decide whether this subject was adequately covered. And if it wasn't covered adequately, you make sure that they do cover it. This isn't a fluff program. It isn't going to work if it's a fluff program. And we're being videotaped, and we're dealing. And I want to make a very important statement. We're dealing with the outliers because, for the most part, everything we hear from the mentors and the mentees is this is a positive experience, and it's a positive experience if you come into it with the attitude of this is going to be a positive experience. I know that when I taught at the university for many years ago. I learned so much more just being a teacher than I did as a pupil, because you had to prepare for class, you had to make sure that your students understood what you were doing, and at the end of the day, I was a better lawyer from what I taught. And I think it's the same thing as a mentor. If you go into this knowing that you've got to be prepared, that you have information to transmit, it will make you better practitioners, and it will make those people that we're releasing on the public better lawyers. And that was the goal of the program, and it still is the goal. And we rely upon all of you to make that happen and make this the great bar that it is. That Bill founded 43 years, me 37 years. This is the best. And it's a great profession. It's got a lot of challenges. It changes every year. It seems to get more and more challenging. But it's up to us to keep it great. Any questions or comments? Please.
I have mentees, and they energize me as a mentor.
Thank you.
That's
Yes.
why I like having them during this practice, which I just like to energize me. But I always get the same question. That's my opinion. Is I get down to page 7, and it's discuss practical ways to manage loss of debt. And I have nothing for it. So I need for some advice.
Okay, I'm ready.
Have a question.
Any ideas?
Janet has her hand up.
As one who has dealt with law school debt, I talk to them about making sure they stay in touch with the Loan Servicing Center, because there's all sorts of programs that you can get deferment, and then I talk to them about the pluses and minuses of those deferments. And the thing with the student loans, I know when I was having to deal with them, is they will work with you if you work with them. If you blow them off, then they will come after you, and it's not pretty. But there's a lot of deferment programs, and I always encourage them, if you can pay the interest, pay the interest. And I tell them some horror stories that I know of what happens when you just keep deferring them. And I have a friend who got a PhD, and she got out of law school. It wasn't law school, but she got out with like $30,000 in debt, and now it's like $240,000. And she's a professor, and it's just so that's I tell them some horror stories, because somebody is, well, you may not be able to do some things you want because you've got to deal with the loan. But I just tell them to pay attention to them.
Thank you, Janet.
And can I add on to that one other point? I do actually still have student loan debt, but I graduated probably the same time Susan did at the lowest interest rate. But is also, I remember when I graduated, to consolidate your debt, like your federal loans and stuff like that. I mean, I think it's hard. It's almost like you want to get the students before they went to law school. I went to the cheapest law school I got into in the country, and so therefore my education was very cheap. And so I was planning ahead that I could work at the Gap when I graduated from law school if I didn't want to be a lawyer. But a lot of kids don't know that. They go to private school their first year of college all the way through their graduation of law school and have like hundreds of thousands, which is probably odd for people that are sitting up here, but they can rack up over $200,000 easily in law school combined debt.
And I think this, when I first mentioned the job market was so bad, you know, they seem very stressed out about debt and paying bills. And I had one of them sharing the cars with one, you know, the husband worked in law school. So it was just, I didn't have a lot of advice for her, but I was trying to get a job, you know, those meet some people.
I mean, I can say, when we've hit that topic, I've tried to give some financial advice where you can give it, you know, just the things on consolidation is available, keeping in touch, you know, understanding what deferment, how it impacts some of, you know, just, and it's short talk, but I can tell you I've spent a lot of time talking about when you find out someone's got some debilitating student debt, really overlapping it into the abuse issues and in terms of substance abuse or other factors that actually bring lawyers down, and sort of to be able to reach out for help. Because that, to me, is one of the overriding messages that I try and leave people with on any issue, is they have resources to reach out to help in this community. It starts with me as their mentor, but there are a list of other, you know, a variety of places that they can go to get help for whatever particular issue it is. And even if it's just calling back in to say, hey, I've got this issue, point me in the right direction, that's kind of the message I try and leave them with on that level.
And money, by the way, is a high percentage of what we see in discipline, where you start getting into money trouble. Now, student loan, we haven't seen one like that yet. But the huge majority of these cases, no matter what the impetus is that brings them into the downward spiral, a huge percentage are all money. So money management, whether it's student loan or trust accounts or anything else, huge.
The debt issue is a national problem. People are talking about it as it might be the next housing bubble issue. And so I think you're going to see, from what I read, some federal legislation that's going to try and do something to ease it. But in the meantime, I think all of the suggestions in the room, most importantly, like with your clients, staying in touch with your lender, trying to get your lender to be real. And I don't know whether there's any, is it still not allowed to discharge debt in bankruptcy?
My understanding, you can discharge.
So we're going to just have to struggle with this, because it is, one of the nice things that I can say about what Boyd is doing is that they have lowered the number of candidates they are taking into the class because of to not flood the market with people that can't get jobs, which is the responsible thing to do. So at least our law school, and of course not all of our mentees come from Boyd, is trying to respond to this in a responsible way, in a bad way. And now, the one thing I've learned from Justice Cherry, through my Inns of Court mentorship, is the best thing you can do as a program leader is end the program on time. Thank you very much for your cooperation. Panelists, thank you for all your help. Staff, thank you for this.